Inheriting a house with a mortgage, when is probate not necessary? That's our topic today. Let's get started right after this. Hi, I'm Kim Ward, certified probate real estate advisor and expert at helping executors and administrators with homes in probate. Welcome back to my channel. Inheriting a house with a mortgage, when is probate not necessary? First thing you need to know is know whether the probate courts need to get involved. Here in San Diego, the legal transfer of property from a decedent, the person who's passed away, to a beneficiary, a living relative, can sometimes require court intervention, and the process is called probate. In the event that your loved one left a trust and the real property, the home of the decedent, is in the trust, you may not have to go through probate. But if they did not leave a trust, and even if they left a will, you're probably going to have to go through probate. That's here in San Diego. However, other states have different laws. It's important that you speak to someone that knows the actual laws in your state. And when I say in your state, I mean the state where your loved one, the decedent, lived, and that was their state of residence. That's where you'll have to go through probate, perhaps. In the case where there isn't a trust or a will, typically the closest living relatives will become the beneficiaries. And technically, they could have the ownership of the loved one's property. In most cases, when there are more than one beneficiary, that property, the home of the decedent, needs to be sold in order to get everyone the proceeds from their loved one's estate. There are 3 types of property ownership that will help determine what happens with the real property of the estate. And of course, that's after the death of the owner. First one is sole ownership. Any property that is owned by only one individual is under a sole ownership. This property isn't transferred to anyone else after the death of the owner unless it's been stipulated prior to the individual's death. Property that is titled under sole ownership includes bank accounts and investments. Number 2 is joint ownership. Joint ownership is property that's owned by multiple people. This kind of ownership can be passed on to all or one of the people on the title certificate. Sometimes you'll see things that are called rights of survivorship. Joint ownership without rights of survivorship divvies up the property amongst the owners. Number 3 is title by contract. This type of property is distinguished by the fact that it can be passed on to the beneficiaries upon the owner's death. Life insurance policy and retirement accounts can fall under this category. It's really important to speak to an experienced attorney to determine how your loved one's property is titled. If it is determined that you will need to go through the courts in order to transfer the decedent's property, then that attorney can represent you through the process. You'll need to settle all the debts of the decedent, and if you intend to sell your loved one's home, you'll need to keep up with the home's expenses, the taxes, the property insurance, utilities, things like that. If it happens to be in a community that has a homeowners association, you'll need to keep that up also. If your loved one's estate has a will and has named an executor, that is the person that will be responsible for taking care of all these items. The other thing I didn't mention was that if the property still has a mortgage, you'll be responsible as the executor or as the appointed administrator to keep up with those mortgage payments also. If all of these expenses are a hardship, there are ways around it. You'd need to speak with your attorney or a certified probate real estate advisor like myself to give you some other ideas of how you can take care of the property but not all of the expenses. Something that I want to share with you is that many of my clients, their loved one had a reverse mortgage. And once your loved one passes away, that reverse mortgage will be sending letters to the house, or if they get your address and information as the executor, they'll be sending letters that may sound a bit threatening, talking about that they would foreclose on the property and such. There are ways around that. I've helped many of my clients, so just reach out to me and I can explain how you can protect the estate from having any problems with the reverse mortgage while you're going through the preparation, the marketing, and successful sale of your loved one's home. You'll want to determine whether it's possible for you to sell the estate property. If your loved one has named an executor and beneficiaries in a will, then you'll just want to get permission from the probate courts in order to start the process of selling estate assets. If the executor and the beneficiaries disagree with how to handle the estate property, especially the real property, the home of the decedent, then you'll have to go to court to have that settled. Of course, to ease the process of selling the property, you'll need to have the proper paperwork. If your loved one died unexpectedly, you'll have to go through all their belongings, hoping to find the paperwork that would then appoint you as the executor. Looking for that will, looking for any important papers is very important. Here's a list of the most important documents that you want to locate in your loved one's home. A copy of the homeowner's insurance policy, any bills or receipts for bills, of course your loved one's will, bank accounts, any and all bank account documentation, and any and all investment account documentation. As the executor or the administrator, you will be responsible for paying any taxes on behalf of your loved one. Federal law may have you paying estate taxes upon the transfer of the property. That's something that you'd want to speak with your attorney or your trusted tax advisor. Additionally, you may have to pay taxes on the property once you've sold it. Again, speak with your tax advisor. And paying all these taxes can add up. And unfortunately, if you do have a situation where you have to pay taxes, not all estates do. So that's why it's important to speak with your attorney, your tax advisor, and a certified probate real estate advisor like myself. You want to get accurate answers to your questions. Now, selling a home with a mortgage is not very difficult. It's just part of the process that we go through. And as long as you're prepared ahead, knowing the facts, knowing the numbers, like I always do a seller estimated proceeds document that would include the mortgage payoff in it, so you will be able to know and share with the beneficiaries the estimated amount that they might receive upon the closing of the probate. And finally, what would happen with the mortgage is that once the property is sold, that mortgage will be paid. Any liens on the property will be paid through the escrow process. You'll be well aware of those liens and mortgages through that process, and then once we close escrow, all of that will be paid, and the proceeds will then be wired to the estate account that you will have set up. So touching on one last thing is finding the right certified probate real estate advisor or someone that is an expert like me with probate to help you through that process is a critical part of you being able to, I like to call it, press the easy button and know what's happening all along the way, and have someone who's done this hundreds of times helping many executors, administrators, and trustees through the process is really important to you. I hope you found this of value. Go ahead and hit that like button if you did, and go ahead and comment or put a question down below, or reach out to me if you'd like. And to receive notification of my weekly videos all about probate real estate, just hit that bell button and subscribe to my channel. Thanks for watching. I look forward to seeing you soon. See you next week.